Hey folks, I'm Greg McLawsen, the Affidavit of Support lawyer. It would probably help if I put my microphone on. There we go. Greg McLawsen, the Affidavit of Support lawyer. I've spent the past 10 years enforcing the Affidavit of Support in federal court. Speaking of federal court, one issue that comes up really often, I've spoken to 2 people this week who had this issue, is if you have a divorce going on, can you bring your federal lawsuit to enforce the Affidavit of Support while the family law proceeding, while the divorce is still going on? The bottom line is, yes, you probably can, but let's talk about some of the reasons this is a little bit complicated. So first, why would you even want to think about bringing a separate federal lawsuit if you're already in a divorce court? Can't you just enforce the Affidavit of Support there? Yeah, probably. In most states that have case law on the topic, that includes California, North Carolina, Texas, Alaska, Illinois, lots of states say, yes, you can enforce the affidavit in family law proceedings. What happens is, first of all, good luck finding an attorney who's able to do that. Happens very, very often that the family law attorney that you talk to has never even heard of the Affidavit of Support, let alone has the ability and expertise to enforce it in a family law proceeding. Same thing is going to be true of the judge. That judge has probably never seen the Affidavit of Support before, so you're going to have to do a lot of education in the family court proceeding to bring the judge up to speed on what's at issue there. Even when those things happen, I can tell you that it is very often the case that family law judges end up awarding less than what we believe is owed under the Affidavit of Support. So for those reasons, oftentimes folks are curious about whether they can bring the Affidavit of Support claim in federal court even while the divorce is going on. And again, the answer is probably yes, but let's look at why that's complicated. Lots of legal terms have complicated legal ideas, have complicated legal names, but they're actually kind of straightforward and intuitive if you think about it. So there are these ideas called claim preclusion and issue preclusion. The basic idea there is that you gotta pick one legal forum to assert your claim, which is to say you can't go into family law court and litigate the Affidavit of Support and then turn around the next day and file a federal lawsuit doing the same thing. A judge in either one of those courts will say, come on, pick the court where you are trying to bring this claim. You can't do it in both proceedings. That's the basic idea of res judicata and claim preclusion. Essentially, you get one bite at the apple. You don't get to keep raising the same claim. And so, if you are in family court proceedings and you have already brought up the Affidavit of Support and said, hey judge, I think I'm entitled to alimony based on the Affidavit of Support. Well, if you then simultaneously go into federal court and assert a claim in that court based on the Affidavit of Support, it's not unreasonable for the federal judge to say, hey, you're already trying to enforce this in the family law proceeding. You can't do it in both tribunals. So that's easily fixed by, if you want to bring this claim into federal court, well, don't bring it up in family law proceedings. Pick your forum. In my opinion, federal court is usually the better choice. Don't bring up the Affidavit of Support claim in family law proceedings, save it for federal court, and then you can bring it up there. There is a deeper and kind of more vexing procedural issue that presents itself, which is the idea of the domestic relations exception. And there are also some related doctrines, but the basic idea is that federal courts don't want to interfere with specifically a family law proceeding, but also other ongoing state court matters. The cases in these tend to be complicated, like multi-state lawsuits where you've got like 2 states in the United States fighting over water rights and things like that. And federal courts say, hey, look, if you guys are battling it out in a state court, you can't simultaneously like jump into federal court when you don't like the way things are going in state court proceedings. But even more specifically with domestic relations matters, the judges don't want to step on the toes of state judges who have exclusive jurisdiction over family law proceedings. So what tends to happen if you file a federal I-864 enforcement lawsuit while a divorce is going on, the defendant, if they're smart and have good attorneys, will run into federal court and say, Judge, you should be really worried here, because if you allow us to litigate and rule on this affidavit of support issue, that's going to end up interfering with the judge's ability in family law court to proceed with the divorce. And that's a bunch of baloney. Why? Because the affidavit of support issue is a distinct and separate issue. Family law is going to involve the division of assets within the marriage. It's going to involve potentially child custody, child support, alimony, all of these factors that can be decided completely without reference to the affidavit of support. The affidavit of support feels domestic-y, maybe is one way to put it. It feels like a domestic relations issue because in this situation, it's going to involve two parties to a marriage. But that's really incidental, because where the affidavit comes from is, of course, a federal statute that doesn't actually care if the parties are married. It doesn't care about any of the facts of the marriage. It cares only who the visa petitioner is. And the rights under the affidavit have nothing to do with the length of the marriage, the quality of the marriage, who was a jerk, who was a nice guy, who did this, who did that. None of that matters for the affidavit of support. The only thing that matters is, did the petitioner sponsor the immigrant? Yeah, they did. And then what is the immigrant's income? If it's under 125% of the poverty guideline, then the sponsor has to pay for the difference. So affidavit of support litigation does not require family law judges to wade into the complexities of marital law. They're very distinct, separate issues under the affidavit. And for that reason, we've had success going to a federal judge. So when the defendant raises this issue of, hey, watch out, you're going to mess up the family law proceeding, we've been able to correctly get judges to rule in the federal context, no, this is not going to interfere with the family law case. Yes, it's the same parties, but it's a distinct standalone issue that arises under a federal statute, and a federal court doesn't have to bow out of that case, even while the domestic relations case is ongoing. The Pachaw litigation out of the District of Montana within the Ninth Circuit Court of Appeals is a good example of a judge very carefully walking through that issue. So, not only can you go ahead and assert that affidavit of support claim even while a divorce is ongoing, it's probably also a good reason, a good idea to go ahead and make sure you do it. Why? Well, this goes back to this idea of you get one bite of the apple. If you proceed with the family law case and you keep the affidavit of support claim kind of in your back pocket, you know, you've got this claim, you know you're going to raise it eventually, but you don't want to go ahead and do it. What the sponsor is going to argue down the line is that you lost your chance to do that. The sponsor will say, hey, we were in family law court together. The family law court, according to the law in most states, does have authority to review this claim under the affidavit. The immigrant could have brought that up in the family law proceeding if they wanted to. They chose not to, and so they missed the boat. Now, there are all sorts of complicated procedural reasons why that's probably a losing argument. Probably the claim is a permissively joinable issue, meaning you can bring it up in family law court, but you don't have to. But let's just not, you always want to create as few legal issues as possible that you'll have to deal with down the line. If you don't bring up the affidavit of support claim while the family law case is going on, you've created one potential issue that the sponsor can raise. Yes, it's probably a loser, but it's one more thing you might potentially have to argue over eventually. So safer option is just go ahead and get that affidavit claim filed. The downside to doing that is probably it's a practical one more than a legal one, which is to say that once that affidavit of support claim is filed, often what you have is a divorce proceeding that's relatively straightforward. A lot of times the parties really don't have much in the way of assets that they're fighting over. Custody might not even be an issue. So you've got a relatively straightforward family law proceeding, and then this kind of bombshell of federal litigation goes off, and the sponsor says, whoa, what's going on here? And all of a sudden they are going to be potentially disinclined to reach a fast resolution of the family law proceeding. So that is a non-negligible strategic consideration, definitely something to talk over with a family law attorney. Usually the way that shakes out is the family law case resolves on its own terms. You know, if the assets and liabilities are going to be split however they're going to be split, child custody and child support are going to be decided on the terms appropriate under state law. And that often happens before the affidavit claim ends up getting resolved in federal court. Sponsors always want to get everything rolled together into one big global resolution. Sometimes that's a good idea for both parties, and sometimes not. As the attorney who's representing the immigrant in federal court, it's usually my position and my client's position that our federal claim stands on its own, and you, the sponsor, can deal with it on its own merits. But in my world, that is a distinct, clear cause of action that stands on its own, and I don't see a reason to allow my client's life in federal court to be complicated by whatever collateral issues the sponsor wants to fight about in state court. That's their problem, it's not mine. In federal court, we are going to march forward to get a clear, fair resolution of that federal claim, regardless of what whatever issues the sponsor thinks might exist in state court. That's not, it's not a problem that the federal court has to deal with, and I'm not inclined to create extra issues for my client. So, bottom line, family law proceeding is going on, divorce is going on. Can you bring the affidavit of support claim in federal court while those are going on? Yes, both yes, you probably can, and yes, you probably should, to create the fewest procedural hurdles for yourself down the line. And to do this, make sure that you are communicating clearly with your family law attorney and making sure they know that you have a separate federal claim that's going forward. Both sets of attorneys should be talking to each other. It's very, very often the case for me that while I'm moving forward with the federal case, there's a concurrent divorce case, and I'm constantly in touch with the divorce attorneys to make sure that we know what's going on in each other's case. And often information can be exchanged that's helpful to the complementary cases. But anyway, yes, proceed in federal court even while the family law court is proceeding, and yes, you should, to make sure you don't create unnecessary procedural hurdles to raise that federal claim down the line. Hope this is helpful. If you have questions about the affidavit of support, jump into the comments. If you would like a free case assessment anywhere in the United States by the ever popular Zoom app, contact us on our website. I do free Zoom consultations every day all across the United States. Happy to chat with you about your claim. Have a good weekend, everyone. Let's see if I can turn this off.